Okay, I agree with that. So we will set them for the same day. I think that would be more convenient for everyone involved. And
Thank you.
we do try to be convenient for people around here. Okay, and so let's set this then for.
Subscribe for weekly courtroom stories.
All right, I have 3 files here. I have, it's like 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373OM. People in the city of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. And Attorney Odette.
Good afternoon, Your Honor. This is the time set for a pretrial and possible motion hearing. I received no motions, and I don't anticipate there being any at this time. And we're just asking if we continue to the jury trial date, as my associate has indicated that Mr. Renfro is not inclined to accept any sort of offer.
All right, thank you for that. And then Mr. Renfro, can you go ahead and state your name for the record?
My name is Christopher Allen Renfro. Today I am demanding a vacate of these matters for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminals, so I'd like those vacated also. No, there was no proof nor burden that the testimony of the cop was proved to be true, and also no evidence. I still have not gotten discovery, which means it doesn't sound like the plaintiff is ready to move forward either. So that's my statement. I demand the court to vacate these matters and restore them whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismiss, but denying that request. One thing that you did mention, though, that I do want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro needs that he does not have?
There's a police report in the criminal matter, and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously, and we do not have to take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff, and that means that there's no discovery on either side.
What it means is that the rules in this court are set by me, and if you want discovery, don't remember, we don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm gonna make sure it happens. So if you want discovery, how do you want to give it to me?
I don't. We're past the cutoff line, and I want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine. In regards to work, also I want to mention, not right, but somewhat maybe along the path towards that somewhere, when you stated the thing about the civil infractions. So you're right, civil infractions are not criminal matters. They are civil infractions for a reason, because they don't carry any penalty of going to jail or anything like that. And so you are entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to that?
I have none, Your Honor. Thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended, commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. It's, again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to King England about what we wanted to see happen in this country. So that's not law. I wouldn't quote that anymore. I would
Three
quote
reasons why
other
I went to
things.
war with England.
One more
was
time.
being an American.
Don't interrupt each other. We're gonna keep doing this, and I'm gonna keep reminding you of that, because if you try to do it while we're having a jury trial, I'm gonna shut it down way faster, because we're not gonna do it in front of a jury. All right, so again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that will be more convenient for everyone involved.
Thank you.
We do try to be convenient for people around here. Okay, and so let's set this then for,
I believe it's already set. I believe there's already notice for the, but I don't believe it was on 8 set yet.
But it was not set for today.
if we set this for August 7th, Mr. Renfro, is that an acceptable, I know no date is acceptable to you, but are you free on August 7th?
I'm summons, I'll be here.
Okay, all right, you'll get a notice. We won't send you a summons, but we will send you a notice for you to
Only
be here.
summons a little bit.
Well, if you don't show up, I'm gonna issue a bench warrant for your arrest, so be fair warned. August 7th, jury trial, 2025, August 7th at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we don't have to bring the jury back. Last thing before we leave, Attorney Odette, you mentioned that, actually, there's two more things I want to talk about before we leave. One, you mentioned that today was set for pre-trial and motion, and I do have, as well have it, there was no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you, Mr. Renfro?
No, I do not.
No? Okay, all right, so I don't know why that was set for that. I know you made an oral motion today, but, all right. Well, then that's not an issue. I will also note that right now, the jury trial actually has a date for Friday, September 5th at 9 o'clock.
Yes, that was the date that we subpoenaed.
This is the date of Mr. Becker's trial.
Okay,
When we originally scheduled it to coincide,
gotcha,
and it just kept moving forward.
gotcha. All right, so do we want to do August 7th or September 5th? It's like either day is gonna be fine.
Well, I think, of course, discretion.
I'd say August 7th is good a date as any, so we're gonna, we had it originally set for, maybe it was, July 25th, we had to move it because there was some kind of emergency or something. I don't remember what happened on that date, but it was something weird. So then we moved it, but we'll move it back to August 7th. That way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we've already talked about this, but it is your intention to represent yourself in this matter, is that true?
It ain't my intention to present this cause.
Okay. You do not want me to ask the public defender's office to appoint you an attorney, is that right? You don't want that, right?
No.
And you do not want to retain an attorney, is that right?
Right, I'm competent, and I will see these matters through myself.
All right, you understand, and we've talked about this before, but you understand that Attorney Odette and people that work in our office that are lawyers have law degrees, they've been through law school, they've been doing this for many years, and according to the people in the legal system, you are gonna place yourself at a significant advantage by representing yourself. Do you understand that?
Advantage? Yes.
At disadvantage. I'm sorry, I didn't say advantage, I meant disadvantage.
I see it another way, but that's.
And that's fine, that's why people represent themselves, so they think that they can do it. And you seem pretty confident to me, as long as we all respect each other and respect this room, everything will be fine and you can represent yourself. I don't have a problem with that. But if we start crossing those lines, that's when we're gonna have a problem, okay? All right, I think that's it for today.
Thank you.
Thank you.
May I have a second for Mr. Randolph?
Yes.
Christopher Allen Renfro appeared before the judge for what was scheduled as a pretrial and possible motion hearing on one misdemeanor charge and 2 civil traffic infractions, though it quickly became clear no actual written motions had been filed by either side despite the hearing being noticed for that purpose. Rather than proceeding through standard pretrial matters, Renfro opened by declaring that he was demanding the court vacate all 3 cases, arguing that he did not consent to the proceedings, that a jury trial without a grand jury would violate constitutional provisions, that the traffic infractions weren't criminal matters and therefore fell outside the court's jurisdiction, and that there was no proof the officer's testimony was true and no evidence supporting the charges against him. The judge listened patiently before firmly stating that most of what Renfro said was legally incorrect and denying his request to dismiss the matters, though she did take a moment to genuinely address his mention of discovery, asking directly whether he had received the police report and citations related to his case. When it became clear Renfro had actually been offered discovery previously but declined it and was now past the cutoff date for requesting it, he clarified he didn't actually want discovery and was simply trying to use its absence as grounds for dismissal. The judge also validated one small part of his argument, agreeing that civil infractions are indeed not criminal matters, which is precisely why they don't carry jail time and therefore don't entitle him to a jury trial on those particular charges, though he would still be entitled to a formal hearing on them, which she planned to schedule alongside his jury trial on the misdemeanor count for efficiency. When Renfro invoked the Declaration of Independence and references to historical letters about the origins of consent and commerce as the basis for his refusal to participate, the judge corrected him plainly, explaining that the Declaration of Independence was never actual law but rather a formal statement made to the King of England explaining why the colonies wanted independence, suggesting he stop citing it and consider referencing the actual Revolutionary War instead if he wanted historical context. Throughout the hearing, the judge repeatedly had to remind Renfro not to interrupt her while she was speaking, warning him that this behavior would be handled far more strictly once an actual jury was present in the courtroom. Despite his continued objections and refusal to accept the court's authority, Renfro proved cooperative regarding scheduling, agreeing to have both the jury trial and civil infraction hearings held on the same date, ultimately set for August 7th at 8:30 a.m., with the judge clearly warning him that failure to appear would result in a bench warrant being issued for his arrest. Before concluding the hearing, the judge also confirmed that Renfro intended to represent himself going forward, declining both a public defender and private counsel, describing himself as competent to handle the matter, prompting the judge to remind him candidly that self-representation typically places defendants at a significant disadvantage compared to trained attorneys, while making clear she had no objection to him proceeding that way as long as courtroom decorum and mutual respect were maintained throughout the case.